We now have argument from an amicus. Again, please remind us who you represent.
Mr. Chief Justice, may it please the Court, my name is Kyle McKee, and I am representing the American Psychological Association as amicus curiae in support of petitioners Evan Miller and Huntrell Jackson. This group respectfully requests the Supreme Court to overturn the decision of the lower court. Now, we as a group recognize that murder is the most horrible crime that can be committed. However, due to substantial scientific evidence, we as a group also recognize the immature and underdeveloped decision-making and judgment qualities present in 14-year-old adolescents. We believe that it is important for the court to take this into account. Now, before we go over the science, it's important to go back and study the court's previous rulings. In Grant v. Florida and Roper v. Simmons, the court held that minors should be tried differently than adults, and this is how we feel in this situation. Minors are more vulnerable to negative outside influences, and their characters are not fully formed. And
Counselor, doesn't the research indicate that the level of maturity differs substantially within those in the 14 to 18-year range, not simply based on the age, but the individual there? Is that not an argument that there are certain individuals within that age range that should and can be treated adequately as an adult based on their subjective maturity?
yes, but as previously noted by the respondent, or the petitioner, it's necessary for a line to be drawn in this situation at 18. And in fact, there is a study that finds that even 17-year-olds scored lower than adults on measures of perspective, which encompass the ability to see short and long-term consequences, as well as the ability to take other people's perspectives into account. So even when it comes to 17-year-olds, they still lack a certain judgment when compared to 18-year-olds and adults in this case.
But couldn't we have a pretrial hearing to determine the maturity and development level of a particular defendant with the court to make a judgment whether or not that individual defendant has the maturity to be tried as an adult, convicted as an equivalent to an adult?
Yes, but the important fact here is that a line needs to be drawn as a precedent for future cases dealing with minors in life without parole. An 18-year-old cannot go out and register to vote or marry or buy cigarettes. It doesn't matter if you're an 18-year-old can. It doesn't matter if you're 17-year-olds and 11 years old. And really what we're trying to put here is a precedent to make sure that minors, their mental capacity is taken into effect and taken into consideration before deciding this case.
So are you advocating a complete ban on life without parole for minors, or simply that the judge be given discretion to consider individual circumstances?
We are advocating for a complete ban on life without parole for minors. Now,
and how is that supported by the psychological studies, the complete ban?
Well, there are several studies that have taken place, and immature judgment is also a main factor here. Minors are, in fact, less capable of mature judgment in comparison with adults, as the court previously noted in Roper v. Simmons. But as previously noted, there was a specific study that took place that even considered 17-year-olds, in fact, compared to 14-year-olds and younger adolescents, which show that 15 to 17-year-olds lack the realism in thinking about future consequences when deciding to create certain actions.
Counselor, if we begin to weigh in on the current psychological research, in addition to maturity of judgment, shouldn't we start at that point opening the door to all of the psychological literature, including incidents of higher testosterone levels among males, particularly through to their early 20s, that has been documented as well? How do we draw lines that says maturity is a psychological factor for constitutional decision-making, but not testosterone and aggressiveness?
But that's dealing with individuals, and the main point of the group is advocating the age number that needs to be taken into effect in this situation.
Counselor, are you suggesting that that standard should be set by legislature, or should that standard be set by the judicial system? Should we, as a court, be left to judge what the standard for a minor's understanding of deterrence, a minor's understanding of the heinousness of the crime, a minor's understanding of the situation they're about to enter? Who should that be left to set that standard so that everyone gets treated in a reasonably fair manner?
We believe that this court should set a precedent for future cases dealing with minors in life without parole. Also, going off of what you were saying, it's important to take into consideration the backgrounds of these individuals. Evan Miller was documented in having attempted suicide a number of times, and Conchal Jackson, members of his family growing up, were involved in illegal activities, and his mother was actually convicted of murder at one point. We see it's necessary. It's not the children's fault that they were brought up in this heinous environment. We feel that the court needs to take scientific evidence and the background of these individuals into effect when deciding this sentence. And
So what is an appropriate punishment for people like Miller and Jackson who commit these crimes at age 14?
well, we believe that they should be punished for these crimes because it's murder. It's the worst crime that could ever happen and be committed. But we believe it's very unfair for a child to have no hope in ever getting out of prison for what they did. Life without parole essentially says that they will eventually die in prison, that they, in a way, it's worse than the death penalty. There's no hope for them. We believe that this court needs to take into account the psychological differences as well as the background differences, as previously noted, when dealing with minors and the issue of life without parole.
Thank you, Counselor.
And therefore, due to the previously stated reasons, the American Psychological Association urges the Supreme Court to rule in favor of petitioners Conchal Jackson and Evan Miller.